let us continue. So we go to the persons who are criminally liable for the commission of a felony. We have the transportation of accomplices and of them. According to him, he has now been entrusted by ABC Corporation to collect their monthly amortizations in the amount of 10,000 pesos. So he collected from unit owners 1, 2, 3, 4, and 5, 10,000 pesos each. Because of his false representation that he is now entrusted, that he has now the qualification and the power to collect this based on the order of ABC Corporation. And these unit owners believed it. And so the unit owners gave their monthly amortization to him. However, X did not remit this monthly amortization to ABC Corporation, but appropriated it for himself as it was needed. And so he was charged with 5 counts of estafa or swindling. Are the charges correct? The charges are wrong. He should be charged only with 1 count of estafa because these 5 acts are considered as continuous crimes. X was impelled by a single criminal impulse. He falsely represented in order to take the money of his unit owners. And he commits a series of overt acts. He collected the amortization from 1, 2, 3, 4, and 5. At about the same time, that is Sunday afternoon, in about the same place, the condo building, violating one and the same provision of the law, Article 315(2)(a). Therefore, he is liable only of 1 count of estafa and not 5 counts of estafa because it is a continuous crime or a continued crime. Former Senator Miriam Defensor Santiago was charged before the Santigan Bayan for 32 counts of violation of RA 3019 because he naturalized 32 foreigners under the naturalization law. He filed a motion saying that the charges were wrong. It should only be 1 count. Supreme Court said the argument of the senator that she was at the time the head of the BID, Bureau of Immigration and Deportation, during the time of former President Cory Aquino. And Supreme Court said yes, it should only be 1 count of violation of RA 3019 because it is a continuous crime or a continued crime. So we have already discussed complex crime under Article 48. We have a compound crime, complex crime proper, and then we have also special complex crime, and then we have also continued crime or continuous crime or delito continuado. There is another one, and this is known as the continuing crime. A continuing crime is one wherein the offender can be prosecuted before the courts of the place where any of the elements of the crime happened or took place. When you say continuing crime, it is otherwise known as a transitory offense. Not all crimes are continuing crimes. The following crimes are examples of continuing or transitory offenses. We have kidnapping, evasion of service of sentence. We have also rebellion. We have treason. We have also estafa by post-dating a check under Article 315(2)(d). Not all acts of estafa are considered as continuing. Only estafa by post-dating a check under Article 315(2)(d). Violation of BP22 is a continuing crime, a continuing offense. In payment of his obligation to Y, X issued a check to Y in Manila. On the maturity date of the check, Y went to his depository bank in Quezon City and deposited the check. However, the check was dishonored by the Drawee Bank in Caloocan City. Y sent notice of dishonor to X. Despite the lapse of 3 days, 5 days, months, X failed to make good the check. Y wanted to file a case of violation of BP22 against X. Where may Y file a case of violation of BP22 against X? Y may file a case in any of the Metropolitan Trial Court of Manila, of Quezon City, or of Caloocan City. Because in any of these places, the elements of the crime took place. In Manila, there is the issuance of the check. In Quezon City, there is the deposit of the check. In Caloocan, the drawing bank dishonored the check. So since it is a transitory offense, a continuing offense, the offender can file a case of violation of Bill 22 in any of the MTC of these places where the elements of the crime happen, provided that the moment he filed a case in any one of these courts, he is already excluded from filing another case in another court. So those are the different forms of complexity of crimes. And you have 15 minutes. So let's continue. So we are finished with the Article 48, that is the complexity of crimes. Under Article 46, the law provides that the penalty prescribed by law shall be imposed on the principal offenders and shall be applied only to consummated felonies. Therefore, all the penalties prescribed by law under Title II of the Revised Penal Code, those penalties prescribed by law shall be imposed only on the offender who is the principal and on a felony which is consummated. So the penalties for a frustrated and attempted felonies are provided for in Articles 50 to 57. Under Articles 50 to 57, if the said felony is in the frustrated stage, you go 1 degree lower from the penalty prescribed by law. If the felony is in the attempted stage, you go 2 degrees lower from the penalty prescribed by law. If the crime is committed by a mere accomplice, you go 1 degree lower from the penalty prescribed by law. And if the offender is a mere accessory, you go 2 degrees lower from the penalty prescribed by law. So the rules are provided for under Articles 50 to 57. Exception to the rule, under Article 60, the law provides that the said rules under Articles 50 to 57 would not apply if the law particularly provides a penalty for the frustrated or attempted stage, or for an accomplice or an accessory. Under Article 62, the law provides that if the crime is committed by a syndicate or organized crime group, the maximum penalty prescribed by law shall be the one imposed. Therefore, being a member of a syndicate or organized crime group is a special aggravating circumstance. A syndicate or organized crime group is a group of 2 or more persons collaborating, confederating, or mutually helping one another for purposes of gain in the commission of a crime. So if he belongs to this group and he committed a crime for purposes of gain, such fact will be considered as a special aggravating circumstance, and the maximum penalty shall be the one imposed on him. Therefore, it cannot be offset by any mitigating circumstance. Under Article 14, we have discussed 2 forms of habituality. We have discussed recidivism, that is paragraph 9, Article 14, and paragraph 10, Article 14, reiteration. There is the third form of habituality, and that is under Article 62, that is habitual delinquency. A person is deemed to be a habitual delinquent if within a period of 10 years from the date of his last release or last conviction of any of the crimes of serious physical injuries, less serious physical injuries, robbery, theft, estafa, or falsification, he is found guilty of any of these crimes a 3rd time or oftener. He is considered as a habitual delinquent. So the elements of habitual delinquency, the law specifies the crime. It must be serious physical injuries, less serious physical injuries, robbery, theft, estafa, or falsification. There must be at least 3 convictions. And last element, each conviction must come within 10 years from the date of last conviction or last release. recidivism is a genetic aggravating circumstance. Reiteration is also a genetic aggravating circumstance. How about habitual delinquency? Habitual delinquency is an extraordinary aggravating circumstance because its effect is to impose an additional penalty on the said convict. That is, aside from the penalty for the crime that he has committed, if he is a habitual delinquent, an additional penalty shall be imposed on him, provided if you add the penalty for the crime that he has committed and the penalty for being a habitual delinquent, it must not exceed 30 years. That is the limitation. The ex committed the crime and he has been convicted by final judgment of the crime of robbery. He served out the sentence. After service of sentence, X was released from prison. Upon his release from prison, just about a year, he was arrested for the crime of theft. Tried, convicted by final judgment, again, he served out the sentence. After service of his sentence, he was again released, but just a month after, he was again caught in the act of snatching a cell phone, so again, he was charged with a crime of theft, convicted of this crime of theft. Again, he served out the sentence. After service of sentence, he was released because upon his release, their family had improved financial conditions. He didn't anymore commit theft, but 5 years thereafter, he snatched the necklace of a woman inside the jeepney. He was again arrested, prosecuted for theft. After trial on the merits, the judge found him guilty beyond reasonable doubt of taking with intent to gain the necklace of the said woman, and the judge convicted him of theft. In imposing the penalty for theft, can the judge consider the aggravating circumstances of recidivism and habitual delinquency? Is he a recidivist? Is he a habitual delinquent? X is a recidivist. All the elements are present. First element, he was on trial for one crime. He is on trial for theft. At the time of the said trial, he has been previously convicted by final judgment of another crime. He has been previously convicted by final judgment of robbery and 2 other thefts. Third element, both the first crime and the second crime are embraced in the same title of the whole theft, and the first conviction by final judgment, robbery, are both under Title 10. And he is also convicted of theft. All the elements are present. X is a recidivist. Is he a habitual delinquent? X is a habitual delinquent. Because within the period of 10 years, after each and every conviction and release, he committed the crime of theft a 3rd time. Therefore, he is also a habitual delinquent. May the court consider both aggravating circumstances, or should the court choose only one aggravating circumstance to consider? The court, in imposing the penalty, can consider both aggravating circumstances of recidivism as well as that of habitual delinquency, because they have different effects on the crime committed by the offender. The fact that recidivism shall be considered by the court, it means if recidivism is not offset by any mitigating circumstance, the penalty to be imposed by the court for the crime of theft, for which he is convicted, must be in its maximum period. And for being a habitual delinquent, there shall be an additional penalty which shall be imposed on him, provided these 2 penalties must not exceed 30 years. Therefore, the judge can consider both because they have different effects on the criminal liability of the other, and one does not absorb the other. So how is recidivism different from habitual delinquency? The following are the distinctions between recidivism and habitual delinquency. First, in recidivism, the law only requires that there be at least 2 convictions. Whereas, in case of habitual delinquency, the law requires there must be at least 3 convictions. Second, in case of recidivism, the crimes are not specified. The law merely requires that they be embraced in the same title of the code. Whereas, in habitual delinquency, the law specifies the crime. Serious physical injuries, less serious physical injuries, robbery, theft, estafa, falsification. The distinction. In case of recidivism, there is no required period of time in between the first crime and the second crime, because recidivism does not prescribe. Whereas, in case of habitual delinquency, the law requires each conviction must come within 10 years from the date of each last conviction or release. Therefore, there is a prescriptive period of 10 years. And lastly, recidivism is a generic aggravating circumstance which can be offset by a mitigating circumstance, whereas habitual delinquency is an extraordinary aggravating circumstance which provides for the imposition of an additional penalty. So those are the distinctions, recidivism versus habitual delinquency. So we have discussed 3 forms of habituality. There is a 4th form of habituality, and that is known as quasi-recidivism, which is found under Article 160 of Book 2. A quasi-recidivist is one who shall commit a felony after having been convicted by final judgment before beginning to serve his sentence or while serving his sentence. So in case of quasi-recidivism, under Article 160, the law provides that the maximum period of the penalty prescribed by law shall be the one imposed. Hence, quasi-recidivism is a special aggravating circumstance. Because the law provides the maximum period of the penalty shall be the one imposed, it cannot be offset by any mitigating circumstance. In case of quasi-recidivism, the thing to be remembered is that the second crime committed must be done after conviction by final judgment, either before beginning to serve the sentence or while serving his sentence. And this second crime must be a felony. Because a quasi-recidivist is one who shall commit a felony after having been convicted by final judgment before beginning to serve his sentence or while serving his sentence. So in quasi-recidivism, it is necessary that the second crime be a felony. The first crime, for which has been convicted by final judgment, can either be a felony or an offense. It is immaterial. What is material and what the law requires is that the second crime be a felony. X was convicted of the crime of illegal possession of loose firearms. Judgment became final and executory. He is now serving his sentence at the New Bilibid prison. In one of a riot wherein he participated, he killed the member of the other gang. And so, he was prosecuted for the crime of homicide. After trial on the merits, the judge found him guilty beyond reasonable doubt of homicide. In imposing the penalty, can the court consider him as a quasi-recidivist? The court can consider him as a quasi-recidivist and impose the maximum period of the penalty for homicide. Reason is, he has already been convicted by final judgment of illegal possession of these firearms. And while serving his sentence, he committed a felony. Therefore, he is a quasi-recidivist. Let us reverse. Let's say he was convicted of the crime of homicide. Convicted by final judgment, he was serving his sentence. While he was serving his sentence, when the prison guards were making rounds, X was found in possession of a plastic sachet of shabu inside the pocket of his pants. So he is now being prosecuted for illegal possession of dangerous drugs. After trial on the merits, he was found guilty beyond reasonable doubt. In imposing the penalty, can the judge consider him as a quasi-recidivist? the judge cannot consider quasi-recidivism as an aggravating circumstance because the second crime that he committed after having been convicted by final judgment while serving his sentence is not a felony. It is not punished under the RPC, but it is punished by special penal law, that is, illegal possession of drugs punished under RA 9165. Therefore, quasi-recidivism cannot be considered so as to increase the imposable penalty. Remember, yesterday I told you about the bar problem wherein the judge convicted the accused about dwelling. Another question there is the aggravating circumstance of quasi-recidivism present? To the situation again, to review you, the situation I stated yesterday, which was in the bar. X was convicted by the judge, and thereafter, while the case was on appeal, X escaped. He looked for the judge, and he learned that the judge, during Saturdays and Sundays, sleeps in the house of the mistress. So he went there, X went there, and found the said mistress and the judge having coffee, and X killed the said judge. So yesterday, I said that one of the questions is dwelling present? Said yes, dwelling is present because ownership is immaterial. The fact is, during Saturdays and Sundays, he uses said place for his rest and comfort, therefore, dwelling is an aggravating circumstance. The other question is he a quasi-recidivist? He has been previously convicted. On appeal, he escaped. While the case was on appeal, he escaped. And then he killed the said judge. He committed a second crime and that is a felony. Is he a quasi-recidivist? He is not a quasi-recidivist because he is not yet convicted by final judgment when he committed this crime against the judge. Under Article 160, a quasi-recidivist is one who shall commit a felony after having been convicted by final judgment. Here, the said case was on appeal and he escaped, found the judge, and killed the judge. Since he is not yet convicted by final judgment, he cannot be considered as a quasi-recidivist. He cannot be considered as an aggravating circumstance.